All right, hello, good afternoon. My name is Adam Slipikoff. I am the founding partner with Howie Slumka of Slipikoff and Slumka, and the firm is My ATL Law. We do these weekly shows where we answer questions that have come in over the past week. Legal questions, often they relate to different areas of practice, depending on who is answering the questions. So for me, my background is in corporate, and we have some experience, I have experience with consumer bankruptcy as well. So today we're going to answer a lot of consumer bankruptcy questions. You may be wondering why I'm squinting so much. It's because we are high atop the Overlook 3 building in Vinings area of Atlanta. Our new office it has a beautiful balcony on the 17th floor, and we are overlooking most of North Georgia. So it's lovely. In fact, you could probably see it in the reflection behind me. I'm going to go right in and answer some of the questions that were raised over this past week. So if you guys have any questions, do please feel free to write in. There is a comment section on the right side of my screen where I can see your questions, and I'll try to respond to them in real time. Also, this video can be reshown and rebroadcast, so you can watch these later if you like. Now, first, please note that this is not legal advice, as we always have to caution with each of these. We are simply addressing generalized questions, and we don't have an attorney-client relationship with viewers. We are not your attorneys, but of course feel free to call us and to see if we could be of any help. Our phone number is 404-800-4001, and you could also find us at info@myatllaw. All right, so I'm going to drive right into one of the first questions, and this may take a little time, but people have been asking a lot about what is the difference between a debt settlement program and bankruptcy. Debt settlement companies are all over the place. People are getting bombarded with television, radio ads, and print media coming to their house saying, if you have X amount of debt, don't file bankruptcy. What you want to do is get into a debt settlement plan, and we'll settle your debts for 50 cents on the dollar or 30 cents on the dollar. And these sound like wonderful plans because they say, we'll protect your credit and we'll give you a fresh start. But there are a lot of things, as you can imagine, that they're not telling you. And that's really what I'm going to be covering first. So what really is a debt settlement plan? These have lots of different names. They can be called debt resolution. They can be called, debt settlement is really the most common, I have to say. But they're workout plans or recovery plans. Every time that you sign up for one of these groups, first ask how much they charge and how they charge. Here's what they normally will charge you. It is right out of the bat, they'll say, well, we don't charge an upfront fee. They all used to, but that was prohibited several years ago. So they charge monthly administrative fees, usually about $20 to $30 per month. And then on top of that, they charge a percentage based on any savings that they can get you. So if you have, the average consumer has 6 debts, and the average amount of each debt is around $5,000. So out of 30,000, if only 3 participate, and you have some savings, and each of them writes it off by, let's say, 50%, well, then that is about, $22,000 that is about $12,000 that it sounds like they've written down. However, you'll see in a moment that it actually adds up to be a heck of a lot more. And here's why. What they're doing is, as they charge these monthly rates, and as they start making phone calls on your behalf, what you're going to find is that you're going to still have to pay interest and penalties on all of the debts. And it's totally voluntary. So if you have 6, maybe 3 may participate. Maybe 2, maybe 1. There's nothing that obligates them to join into a settlement plan with you. Many big companies, American Express, Chase, they are notorious that they will not do any debt settlement plans whatsoever. And these plans, even to negotiate them, can take anywhere from 6 months to 1 year. We've heard of some that can take up to 5 years. And then during that time, though, there's still accruing interest and penalties. So you have many debts that aren't even part of a settlement package that you still have to pay in full, and then a handful that are being subject to a settlement. But if you miss one settlement payment over that period of time, then all of this comes back to haunt you. The interest and the penalties all come back along. Also, so does the original principal. So you get no immediate relief. And in the end, on average, most people end up paying more for a settlement plan than they do if they paid off all of the debts 100 cents on the dollar. Now, here's another big problem. These savings that a debt settlement plan can get you, it sounds like a lovely thing that they're just going to write it off and that's all. The problem is that you're taxed on any of these savings. So the example I gave a bit ago, if you have a couple of a couple of debtors that agree to shave off some of your debt. In the example I was giving, 3 debts, $15,000 total, and they write off half of it. So you have $7,500 of savings. You still have to pay $7,500 towards those creditors. Well, that $7,500 of savings is taxable to you as income. So you're going to get a nasty surprise come next April that all of a sudden you are going to have to write a check to the IRS for all of that $7,500 that was saved. If you're in a 25% tax bracket, that's about $2,500 to $3,000 in taxes that you were not expecting to have to pay. But that is exactly what happens. Another major problem with these debt settlement plans is that they simply aren't effective against aggressive collections. A collector can go do lots of things. They can file a garnishment, they could file a lawsuit, they can try to foreclose on your house, they can try to repossess a vehicle. But as those things are happening, you don't have any way to stop them. And if you're already at that point, then offering a 5-year settlement plan is very unlikely to dissuade them from moving forward. Because at this point, they've already got the court order to foreclose, or they've already got a judgment against you, or they've already started the lawsuit. It's probably often a little too late. So if you just enter into a debt settlement plan, if you think that the garnishment or the foreclosure or the eviction is going to stop, it doesn't. By filing bankruptcy, that gives you a federal court order. The very moment you file, a federal judge issues an order, and this isn't sometimes, it is absolutely every single time. It is called automatic stay, and as the name sounds, it's automatic. At that very moment, every collection activity has to stop. No phone calls, no letters. If there was a lawsuit and you are 1 day away from the jury trial, that will stop. If you are about to get foreclosed on, the very next day, that will stop. So the power of a of a bankruptcy is extraordinary, and it is instant. And I was noting earlier that in the other two problems, the first I said is that they're voluntary, and the second is that, the debt settlement plans are voluntary, and debt settlement plans also are taxed. Bankruptcy, you don't pay any tax on any of the amounts that are written off. Similarly, it's not voluntary. Every single creditor has to stop instantly. You can't have some creditors who say, yeah, I'll abide by this federal court order, and some that say they won't. There are stiff penalties if they violate those court orders. So these are some of the reasons why sometimes it just makes sense to just talk to a bankruptcy lawyer right out of the gate. What we find is that so many people will go to a debt settlement firm and they will go through a plan, and I hate to say this, but the statistics are terrible. A recent study found that almost 90% of people that even get into debt settlement plans never complete them. That's terrible, because things happen in life. And if you are in, let's say, a 60-month repayment plan in a debt settlement, and you get to month 38, and that particular month you've just gotten laid off, or something's happened, or there's a medical emergency, and you just simply don't have the funds. That missing that one payment means that every bit of the contributions you've been making haven't done anything to deal with that debt. It all comes flooding back, interest and penalties and the principal amount. But it's dramatically different in a bankruptcy. A court recognizes that people have extenuating circumstances, and if something extraordinary happens, we would file a request with the court for some leave. The court can exercise discretion and recognize, look, this is a one-time thing, we're going to let this pass, and you don't necessarily have to get, your bankruptcy is not unwound just because of something small. Other things, let's talk about this. For a debt settlement program, one of the things that often troubles me is people seem to think that they're instant. That if you just call this 1-800 number, you have salespeople on the phone. They're not lawyers, they don't know the law, and they're not supposed to know the law. But they will tell you that we will go and call all of your creditors and tell them not to pursue you anymore. Now, like I said earlier, that doesn't mean a single creditor has to listen to them. They don't have to do anything. But if we as the law firm notify a credit card company or a bank and we say, listen, we represent this client, they are no longer allowed to contact you. They have to send all of their communications directly through us. And as I noted earlier, for bankruptcy, it's automatic. Instantly, everything stops. These plans, like I said, can take many months, 12, 24 months, just to even get one plan negotiated. And usually only less than half of all of your creditors will participate. So if you only want to deal with half of your debts, and you also don't mind getting into a 5-year repayment plan where you are going to end up paying 100 cents on the dollar, then perhaps a debt resettlement or debt structuring plan is right for you. However, if you want to get a fresh start, if you are qualified for Chapter 7, then within 2 to 3 months, every single debt that you have is wiped out. I mean, I want to say that again. Every single one of them could be wiped out and reduced effectively to zero. Now, that is if you are doing a Chapter 7 filing and if you meet those qualifications. Otherwise, if you do a Chapter 13 plan, you could get into a Chapter 13 where you are paying off, it depends on your income, of course, and your assets, but you could end up paying 10 cents on the dollar, 20 cents on the dollar. But know this, every collection activity stops instantly. All garnishments, foreclosures, and whatnot, and it is not optional. Okay, I've covered that, and I've spent a lot of time on this issue, so let us answer other questions. We had one lady write in saying that a credit card company stopped sending her invoices, and she was asking if, because she's no longer receiving invoices, does that mean that she doesn't owe the debt anymore? Now, that can be a common misconception. Also, what I also see a lot of people say is that, well, I used to get, I had a Chase credit card, but now I never heard from them for about 8 months, and then all of a sudden now I'm getting a letter and calls from a company. There's lots of these collection groups that buy debt, and they say, oh, well, this is XYZ Funding Company, and they're saying I owe this debt to them. I don't even remember the debt. Well, if I don't remember it, and if they've not been invoicing me, do I still owe? Unfortunately, the answer is always yes. Even though someone sending an invoice is not a legal requirement by any means, no company is required to send you an invoice. They are just simply courtesies reminding you or encouraging you to actually pay. If you borrow money or if you charge on a credit card, you owe that money back plus the interest, regardless. And if they've stopped contacting you and you've heard that they've written it off, even though that sounds encouraging, it doesn't mean it's over. And here's why. What happens typically is, look, credit card companies will charge extraordinarily high interest rates. And if you don't pay it back and you no longer are charging on it, they'll try to collect from you directly for about, could be 6 months, could be a year or longer. But ultimately, they get to a point where they become fatigued and they say, look, we don't think this person is going to be able to pay. It's not worth our time and energy to file a lawsuit against this person. So they decide, what we're simply going to do is we'll sell this debt. Oh, hey, we have Howie Slumka. Let me introduce Howie here. Howie Slumka is my co-partner with Slipkoff and Slumka. Let me finish off this topic.
Sure.
So what we were saying, though, is that if someone does not receive invoices anymore, are they still responsible for the debt? And of course, we've said yes, they're responsible regardless, but at a certain point, even though a company has written off the debt, what does that mean to you? Very little, because their writing it off doesn't free you of the obligation to pay it. All it simply means is that they are themselves no longer calling it a good credit. And what they usually do is they sell these debts off to other people. These funding companies, XYZ Funding, will pay 3 cents on the dollar, 4 cents on the dollar. And what they do is they buy these debts in million-dollar batches, multi-millions, and then they send out teams of lawyers or collection agencies to start collecting. And for them, it's just a numbers game, purely a numbers game. They figure that if you owe $10,000 and they buy your debt for $300, if they can get you to pay $2,000, $3,000, if you pay $3,000 and they paid $300 for the debt, well, they just made a 10-time multiple on their money. So they are hoping and guessing that enough people will cave in or get into a debt resettlement or settlement program with them where they'll get some of the money over time. Okay?
Yeah. I guess the one thing that I would add to that, coming late to the conversation,
That's all right.
Just because you are not getting invoices or even that the debt has been written off, it does not mean that you're off the hook. Even if it's not on your credit report anymore. We have a lot of clients who come in because they think they owe, $10,000 or $15,000, but they know in the back of their mind that there was another $15,000 that they never paid. They owe that as well, and
Exactly.
and a bankruptcy can take care of that and get it discharged. Because even if the credit card company is not coming after you, these buyers of debt that Adam just spoke about, you are on they have you in the crosshairs, and you'll hear from them about a month before the 6-year statute of limitations expires.
And that's where we didn't cover yet, was, if I may, the statute of limitations. So depending on the various states, and depending on how the debt is structured, they can have 6 years or 7 years, and it could be longer on your state, depending, that they can go after you. So even if you stop getting invoices and the debt has sold, this happens all the time. We call them zombie debts, where someone will say, we are now the assignee of Chase credit card or Citibank, and we are demanding you pay us. And of course, they're demanding the full principal and interest plus all, everything that is accrued, all the penalties over the whole 6 years. And it has no the court does not care that what they paid for that debt. They still have bought the rights to collect. All right, let's cover another issue. Something that people had raised to us in another question was talking about garnishments. Now, garnishments are one of those things that, we often say that there are certain triggers that cause people to finally contemplate having to file bankruptcy. I always say this, that there are certain conditions precedent, but then the trigger is what makes someone actually decide, all right, I've got to do something about this. Because even if you have a bad credit score, or if you have lots and lots of debts, some don't mind the phone calls and the letters, but that is one of the top reasons that people do call us, because they just want the letters to stop and the calls to stop. But once it has been reduced to the point where a company has gotten a garnishment against you, now they've collected 25% of your paycheck. Look, most people cannot afford to have a day where they go to get their paycheck and 25% of it is simply not there. And you have options. And as I said before, if you are looking at a debt settlement plan, you're way too late to the game at that point. But let's talk about bankruptcy, Howie. If someone files bankruptcy, there is a circumstance where we can recover monies from if an employer is either not paying the 25% or maybe perhaps they've garnished your bank account. That does happen. A lot of people they go to withdraw money and they say it's zero, and they have no idea how, and it was because of that lawsuit from 6 months ago that they didn't answer. And we always say you have to answer, and you have to deal with it at that moment. But bankruptcy, even after you've missed the lawsuit, you can still stop the garnishment. I'll pass this off, and you can talk about why.
Right. So the old expression, don't bring a knife to a gunfight, comes to mind at this point. You have, by the time you've been garnished, you have a very angry plaintiff. You have a creditor who has written you over the years, spent money trying to collect, they haven't collected, they sued you, they got a judgment, they have a lot of time and effort into this, and they have given up on you. And they don't want at that point for me to call and try to negotiate with them. I can still negotiate with them, but that's using a knife. And I say that for two reasons. I'm going to go out on a limb here. Most people who have a garnishment from one company owe money to other companies as well. Rarely do you pay all of your bills except the American Express. You know, you get into hot water across the board financially. So what happens when you've been garnished, again, is you have one very angry creditor. They're coming after you. And if we just isolate the garnishment and use the legal tools available to either traverse the garnishment, to open it, to delay it, to slow it, you'll be out thousands and thousands of dollars, and you're only looking at the tip of the iceberg. A bankruptcy at that point is a much more efficient, that's bringing a bomb to a gunfight. You wipe out all of your debts, not just the debt that is garnishing you. And that's usually what most clients are going to want to see. The way it works is a single federal bankruptcy filing is more powerful than a state law garnishment. And it stays it. It means the garnishment stops immediately. And some of the good news is when garnishments take your money, they don't go immediately to the creditor. They sit in the court for some time. And as long as we file promptly, we can get some of that money back to you. Many clients are able to pay for their bankruptcy from the money that was already taken out of their paycheck, so it doesn't really cost anything to file. And it's very effective, but the really positive thing for most clients is that we're taking care of much more than just the debt that brought them to us. Someone may come in with a $10,000 garnishment and leave with a $100,000 discharge, and that's very rewarding for me as a lawyer to help people get a fresh start, a much bigger fresh start than they were encountering.
Okay, great, thank you. All right, what we're going to answer next is another question that came in asking about title pawns. There are so many products and options available. As folks start to fall a bit behind in situations, they will try lots of different, I'll call it techniques or ways to tread water, and often a title pawn is one of those things where you can get some immediate cash, and it seems like it is a decent option, or a payday advance, because you're getting some cash, but at the end, they say you keep your car. Well, what I want to say about this is, if you go into a bankruptcy, one of the things that we cannot necessarily do is to stop that car from being repossessed, and that is something that you have to think about. We strongly would recommend against doing a title pawn, because you are losing a very key option at that point go ahead.
Yeah, I would say we're able, if you come in time, we're able to stop the repossession. What we can't do on a title pawn is get it back.
Exactly.
The repossession, the day of the repo is a very firm brick wall on title pawns, but it's not for other loans, and that's why title pawns can be so much more dangerous to our clients.
That's right. And so even if you have one, you still would want to contact us before the car gets repossessed, because if we can stop that repossession, that's a very critical juncture. After it's been repossessed, then it could be a little bit too little too late. So here's what we offer all the time is we like to have people come in. We offer a free 30-minute, and sometimes it'll extend even to an hour, just a free consultation. We don't charge for this, and we talk through what your individual situation is. And if you find for yourself that you have a small amount of debts, well, a bankruptcy may not be best for you, and we would talk about other options that are available, such as doing a direct one-off solution with that creditor. But often a lot of people have multiple debts, and if you have more than 3 or 4, then at least we can explain what the bankruptcy process involves, and then also how you can rebuild your credit afterwards. Because a lot of people don't talk about that issue afterwards, and I do want to spend a minute talking about, does bankruptcy hurt your credit? Of course it does. Does a debt settlement plan hurt your credit? Of course it does. But by this point, though, you've already had major delinquencies and actions against you. If there's ever been a court, pleading filed, that also is going to be affecting you. So at this point, how much is the impact? Well, it's some, but you can at least now draw a line in the sand and rehabilitate your credit at that point going forward. One of the main ways is we like to encourage people to get a secured credit card, right? A secured credit card, you can get them anywhere. If you go to a bank and you say, look, here's $500, give me a $500 credit limit on a Visa card. You can go and pay for everything that you're accustomed to doing, dry cleaning, restaurant. Nobody in the world knows you have a Visa card just like everyone else's Visa card. How yours is secured and maybe perhaps others is not secured. But the perception is no different, and you are rebuilding that credit on day one.
Right.
Also, there's others.
Yeah, well, it's with regard to the damage to your credit, it's rare that somebody who is seeking possible bankruptcy has a credit score that's so high that the impact would be detrimental to them. But sometimes it happens. And with those clients, we pay special attention to it. And if you need a bankruptcy, sometimes it's best to structure the bankruptcy as a Chapter 13. Because in a Chapter 13, even though your credit score may dip while you're in it, effectively it won't matter. Because you can't get new debt, new loans while you're in the 13. But when you get out of the 13, your credit score will rebound much quicker. And we pay attention to that for our clients as well. There are a number of ways that we counsel clients as far as rebuilding credit, because I think that's part of the process. And the number one way surprises a lot of clients. It's get yourself a credit card.
Yeah.
Many people cut up their credit cards and say, I never want to do that again. But we would urge you, get a small limit credit card. It doesn't matter what the interest rate is going to be because it's going to be high, but it doesn't matter because I want you to pay it off every night.
Exactly.
Don't buy a TV with it. Just buy a sandwich or a burrito and then pay it off that night, just like you use cash. And after 3 months of doing that, our clients are able to get more market rate cards.
Man, in fact, your credit is actually enhanced. It's the FICO scores that are created out there. It's Fair Isaac Corporation created these years back. And the way to increase your score is to have more credit available to you and use as little as possible. So to Howie's point, if you have a $500 or $1,000 credit line and you only buy a $5 sandwich, that's a lot of unused credit, and that actually builds up your score faster.
Right.
So yes, we encourage that. Now here's another misnomer. A lot of people think that, well, look, if I get into a bankruptcy, that every sort of financial transaction you have has to just go to pot and you have to just abandon it. Some people, especially with low interest rates on mortgages right now, love the mortgage they're in. You do not have to lose your house. You do not have to lose that mortgage. And I can't stress this enough. I'm going to give an example of, let's say, there are mortgages now, they're back below the 4s. And if somebody has taken out, you're 8 years into a mortgage and you're paying 3.5%, and you've built up equity in your home, you love your home, you can still file for bankruptcy to get rid of all of the unsecured debts, and then you're allowed to assume. The court will say, well, which of these contracts, which of these loans do you actually like? And you would say, well, I really like this one. My mortgage is fantastic. And you can basically opt to take that outside of the whole bankruptcy universe. And you'll continue as you were before, paying that great 3.5% interest and building equity over time.
Right. It's even more exciting than that for car loans. You can sort of do what we call a hard assumption or a soft one. The hard assumption is when you say to the court, I love this car loan, I love the car, and I want to reaffirm it and embrace it like I never filed bankruptcy. And then it continues to help your credit as you pay it off, and everything's good. But if you ever miss a payment, they can come get the car and they can sue you for the difference. So a soft reaffirmation is where we call it a ride-through. You say, I like the car, but I don't love it, and I like the loan, but I don't love it. I'm going to just keep on paying it. And when I choose on my time frame to stop paying it, I get to hand you the keys and walk away from this debt, and that can be helpful for cars that are older. You may have a $3,500 transmission job on a car that's only worth $2,000, and then you get the right, if we file the bankruptcy and do one of these soft reaffirmations, to walk away from it. So there's a lot of options, not the kind of options I expect most people to be able to take advantage of without a lawyer, and that's why we're here to help.
Okay. And one last thing we're going to finish up with is one more question that we've got, which is how do I deal with a business situation? There are a lot of people, more now than ever before, that own their own business. People are freelancers, they are contractors, they are consultants, and we have a very dynamic economy, and we have a great employment rate right now. So people are busy, but you never know. It could, through no fault of your own, you could have personal credit that is absolutely excellent, and you could have one very valued client or customer who just simply doesn't pay at some point, and then you find yourself unable to pay the bills for your company, and then you also find yourself with a very large loan that you've personally guaranteed. That happens far more than anybody realizes. So you don't have to have a complete credit crunch. We've never really talked about in any of these videos that we've done about Chapter 11s for bankruptcy for companies. But it's worth noting that a company can file for a Chapter 11, a reorganization, or it can file for a Chapter 7, which is a dissolution, and it doesn't necessarily have to affect you personally. If you've personally guaranteed loans, then you'll want to talk with us right away about how we can deal with those. But a Chapter 11 restructuring or Chapter 7 for a company is a great option if you are looking at how to get through a very, very difficult time. Because just like people get sued, companies do as well. Any comment on that?
Yeah, just that, again, a Chapter 11 is definitely not something that you can go into alone. It's very complicated. For small businesses and individuals, because they can also file Chapter 11,
That's right.
it often feels like fitting a square peg into a round hole, because Chapter 11 was written for companies like Delta Airlines. And when we have a small company, there are things we need to do in those Chapter 11s that just feel very out of place, but they can be helpful. The most important thing for a Chapter 11, and hear this, if you have a business and things are not going well right now, don't wait too long.
Yeah.
After your accounts have been frozen, or after the landlord has terminated your lease, it can be too late to help with a Chapter 11. You want to get your hands around a Chapter 11 when you're sort of still see the downslide, but can imagine how to bring yourself out of it. That's when to file. So call us and we'll help you out.
Okay. Well, listen, we want to thank you for joining us. We had a great time always doing these.
Can't beat the view.
That's true. We really have a great view of all of downtown and the mountains behind us.
That's my bald spot.
Boy, I guess you can't see all that. Listen, let me share with you guys our contact information, so don't hesitate to call us if you have a question or an issue. Our phone number is 404-800-4001. Again, that's 404-800-4001. And you can always find us at info@myatllaw. And our website, of course, is myatllaw.com. We look forward to talking with you guys next. In fact, we see a question up here, and I'm going to write back separately to Chanel with your answer. All right. Well, thanks so much, and we look forward to seeing you again next time. Take care.